The United States' unclear crypto policies have led businesses like Ripple to explore investing outside the nation. Brad Garlinghouse has claimed the Ripple CEO advised the U.S. to follow the U.K. and Singapore. How do you think this will affect the cryptocurrency and the U.S. economy? We will answer these questions in today's pro-XRP lawyer John E. Deaton just tweeted to his 272.4 followers about the U.S. federal court's long-awaited hearings and decisions. In reaction to Coinbase's chief legal officer Paul Grewal's tweet, Deaton predicted a big day for crypto on Wednesday. Grewal's tweet listed tomorrow's amazing activities: the SEC hearing on Binance's asset freeze, the Hyman papers, and Coinbase's appeal were the events. The SEC filed a request to freeze Binance's assets the week before, affecting hundreds of accounts. U.S. District Court for the District of Columbia will hear the case on June 13, 2023. On Wednesday, the contentious Hyman papers are anticipated to change the SEC-Ripple conflict. Deaton tweeted that the papers will greatly affect the SEC's litigation against Ripple and other exchanges. Coinbase petitioned the SEC for regulatory clarity. The Third Circuit ordered the SEC to reply within 7 days, which is anticipated to be June 13. Grewal said, "Not every federal court day is eventful in crypto, but tomorrow is." Deaton replied to Grewal that former U.S. President Donald Trump's arraignment will also take place tomorrow. According to reports, Trump landed in Florida for his first court appearance on June 13 after being indicted for mishandling national security secrets. He was accused with not helping the authorities retrieve the paper. An XRP and Ripple devotee tweets Ripple's filings again this morning. The filing is on Court Listener. The SEC's Ripple case was highlighted on Twitter with this screenshot. The tweet above shows Ripple's filings crucial information. Following the Hinman documents revelation, the SEC's Ripple lawsuit will likely have a major confrontation tomorrow. Twitter also posted a Securities and Exchange Commission v. Ripple Labs Inc. complaint. Big Cases bot uploaded Doc 827, declaration in support of motion. Cyril then gives traders special techniques to tank their research productivity. First, DeFi fans need Token Terminal. This program collects blockchain and dApp financial statistics, including sales, earnings, and user growth. Cyril claims this helps traders make data-driven judgments. Both tweets received overwhelming support and unwavering optimism for Ripple and XRP. Most replies think Ripple and XRP are close to triumph and will likely moon shortly. After a protracted SEC-Ripple Labs dispute, XRP may shine sooner than predicted. The document shows lawyers joining and leaving the lawsuit. Both sides are ready for their ultimate clash. Others await news as the crypto world awaits the conclusion of the most famous crypto case. The crypto world is also awaiting Binance's asset seizure and the SEC's reaction to Coinbase's appeal. In the ever-changing world of crypto legislation, Ripple Labs' lawsuit against the U.S. Securities and Exchange Commission SEC stands out. Ripple, the business behind the XRP cryptocurrency and a participant in a legal dispute with the SEC since December 2020. As the lawsuit nears its conclusion, Ripple CEO Brad Garlinghouse has emphasized the necessity of continuous efforts to explain the industry. Brad Garlinghouse, EEO of XRP developer Ripple, has been an outspoken proponent of uniform crypto market regulation. He argues that a clear framework is essential for the development and success of businesses and the safeguarding of customers. In the absence of such certainty, Garlinghouse argues, American entrepreneurs and investors may go abroad for opportunity. He believes rules are necessary to protect investors and keep the market honest, but he emphasizes the need for a compromise that allows for innovative problem solving while also addressing legitimate concerns. Legal proceedings between the corporation and the SEC are coming to a close, but Garlinghouse warned that this is just the beginning of a much larger dispute for the industry, and that the fight for regulatory clarity has to continue. The Hyman documents were released on June 13 as part of the continuing litigation between Ripple and the SEC. On the same day, Garlinghouse filed a complaint against the agency and posted a video on Twitter explaining what had happened. Garlinghouse, in a video uploaded on June 17 and using the Hinman documents, says that the SEC knowingly created confusion about the rules, and they used that confusion through enforcement. Garlinghouse, in his address, condemned the SEC's actions as bad faith, plain and simple. This he said, should have been obvious from the start, as the lawsuit against Ripple was first brought in December 2020. Very Grinch-like touch, since it was days before Christmas. As he put it, this is the very definition of putting power and politics over people and good policy. In his defense, Garlinghouse claims he never was informed that XRP was deemed a security, and that he answered every question the SEC had prior to the complaint being filed. Garlinghouse argues the struggle for regulatory clarity is not over, even if the Ripple SEC issue is settled shortly. According to him, the case has spurred debates and conversations about how crypto will be regulated in the future, which is a good thing. A decisive verdict in the case is necessary for the establishment of a legal precedent and the elucidation of a future course for the industry. In order to foster innovation while protecting investors, Garlinghouse pledges to continue engaging with lawmakers and regulators. He stresses the need of having open and honest dialogue with regulatory entities to establish clear standards for how cryptocurrencies should behave inside the present financial system. He claims that the SEC is looking to kill innovation and the cryptocurrency sector in the United States, and that the Hyman speech isn't about any one token or any one blockchain, but rather the SEC's general approach towards the cryptocurrency company. Furthermore, the documents at best suggest, as stated by Garlinghouse, that top SEC officials couldn't agree on the policy and personally urged Bill Hyman not to confuse the public about the rules for crypto. Publicly accessible data show that editors were concerned that Hinman's claim that ETH, is not a security would make it difficult for the agency to take a different position on Ether in the future. However, Garlinghouse said that the data showed that Hyman deliberately ignored the law and attempted to create new laws, which was at worst. Since the SEC may take action against other crypto firms in the future, he emphasized the significance of industry-wide coordination. We may be nearing the end of our litigation, but he stressed that for so many others, it is just starting. Thus, the fight for clarity must go on. Binance, a cryptocurrency exchange, was sued by the Securities and Exchange Commission on June 5 for allegedly selling unregistered securities. The next day, the regulator took action against Coinbase for identical grounds, according to newly disclosed court filings in the Ripple vs. SEC's lawsuit. Ripple is said to have paid 6 exchanges between $1 million and $5 million to list XRP. In light of these allegations, Ripple's chief technology officer, David Schwartz, has issued a response to provide some light on the situation. Schwartz elaborated in response to a conversation started by the anonymous self-proclaimed detective. Remember that in the newly published court filings, Exhibit 220 was highlighted by the crypto basic as evidence that there are reasonable reasons to assume that XRP does not satisfy the Howey test. If this came from the SEC itself, some supporters have said it would be game over for the agency. However, Mark Fagel, a former attorney for the SEC, has said unequivocally that the SEC did not author the paper. Scam Detective has recently tweeted about this as well. But he also claimed that a legal company drafted the agreement on behalf of Grayscale Investments. Scam Detective said that the legal firm's conclusion that XRP is not a security was supported, in part, by the fact that Ripple does not facilitate XRP trading on the secondary market. However, recent findings suggested that Ripple spent between $1 million and $5 million to 6 exchanges in 2017 to list XRP. Scam Detective determined that the Grayscale XRP Investment Trust dissolved in January 2020. 1. Due to these charges. According to the accusations, Ripple has been after Coinbase for years to offer XRP. In answer, Schwartz provided some clarity on the situation's complexities. The assertions made are, he stressed, only allegations and the truth is far more nuanced. Schwartz provided an example to illustrate the processes that may underlie such claims. He elaborated that Ripple may initially choose not to pay a hefty price requested by an exchange in order to list XRP. The only way Ripple could utilize the exchange for auto purposes and force XRP's listing on the platform is if it subsequently discovers a chance to develop a worthwhile payment connection with that exchange, in which case it would pay for the integration fees. Instead of only listing XRP, this payment would help Ripple achieve its greater aim of increasing its on-demand liquidity (ODL) service. Schwartz made it clear that this is just conjecture. He stressed that litigants often make charges in the most negative light imaginable without really contradicting the truth. He warned against taking the charges at face value and emphasized the need for a balanced assessment. You may recall that claims appeared in the past suggesting that Ripple paid exchanges like Coinbase to list XRP. Notably, this month, scam detective questioned Schwartz how much Ripple paid Coinbase to include XRP, reviving long-standing suspicions first reported in a Bloomberg piece in 2018. The story of Coinbase listing XRP is the only story I most wish I could tell that I can't, Schwartz said at the time.